First, the bill will remove mandatory minimum sentences and disqualification periods for first-time offenders. This will give our courts greater discretion to determine the appropriate sentence based on the circumstances instead of the current situation where there are prescribed mandatory minimum sentences. To be clear, first-time offenders will still face penalties. These penalties will be determined based on factors including the nature and severity of the harm caused to the victim and the level of culpability of the accused. With the removal of the minimum sentences for first-time offenders, we will make corresponding changes to lower the mandatory minimum imprisonment term for repeat offenders. Specifically, for dangerous driving offences causing death for repeat offenders, the mandatory minimum imprisonment term will be lowered from 4 years to 2 years. For dangerous driving offences causing grievous hurt, it will be lowered from 2 years to 1 year. This adjustment aims to create a more gradual progression in sentencing between first-time and repeat offenders under the new regime. The intent of these amendments is not to signal a more lenient stance towards repeat offenders. Repeat offenders will continue to be subject to mandatory minimum imprisonment terms and disqualification periods, and where warranted on the circumstances, the courts may in fact impose sentences higher than these mandatory minimum terms. Second, the bill will provide the prosecution flexibility to proceed on a hurt charge, even where grievous hurt has factually been caused. Because of the manner in which the dangerous and careless driving offences are presently structured in the RTA, the High Court has ruled that where an injury designated as grievous hurt was factually caused as a result of the accused driving, the prosecution can only prefer a charge of dangerous or careless driving causing grievous hurt and not a charge of causing simple hurt. As a result of this ruling, if a driver drove carelessly and caused a pedestrian to sustain a fractured finger, the prosecution presently does not have the discretion to proceed on a charge that is anything less severe than a grievous hurt charge. Third, the bill will adjust how a motorist's track record will count towards being classified as a repeat offender for a dangerous or careless driving offence. Being classified as a repeat offender leads to enhanced penalties for the offence. Today, a motorist is classified as a repeat offender if he has prior conviction of dangerous driving, careless driving, speeding, or illegal speed trial offence, colloquially known as illegal street racing. Specific to a prior conviction of a speeding offence, we will amend the RTA such that a motorist will only be classified and charged as a repeat offender if he satisfies two criteria. First, the motorist had at least 2 prior speeding convictions in which he had sped in excess of 40 kilometers per hour of the road or vehicle speed limit. And second, at least 2 of those prior speeding convictions occurred within the 5 years preceding the motorist's current dangerous or careless driving offence.